A federal high court sitting in Uyo has adjourned a hearing on a case brought before it on a plan to direct allocation of revenue to local government councils by the federal government. The 31 local government councils of Akwa Ibom State and the Attorney General of the state are in court to challenge the legality of the plan action. The plaintiff, the 31 local government councils of Akwa Ibom State and the Attorney General of the state are in court to determine whether, pursuant of Section 4, subsection 7C, Section 1 and Section 162, subsection 5, 6, 7 and 8 of the 1999 Constitution as amended is constitutional for the first defendant, the Nigerian Financial Intelligence Unit, to issue guidelines to regulate the state joint local government account in Akwa Ibom State, which is within the exclusive powers of the state. Counsel to the plaintiff, the Attorney General of Akwa Ibom State, in his presentation prayed the court to grant a restraining order against the Nigerian Financial Intelligence Unit, stopping the commencement of the guidelines, which was to take effect from June 1, 2019.
Now that the parties are before the court, automatically what ensures is that both parties would obey the court. No party will venture to go and enforce or seek the implementation of those guidelines, because both parties are before the court, and that is what the point that we're trying to make before the court. It is natural that it is incumbent on every person, be it a statutory body, a natural person or what, that is brought before the court. You are bound to obey the court, and that is where we are bound today. I must also add this. The court has been magnanimous enough to adjourn the matter to the 21st of June for the hearing of all pending applications, including the originating summons itself, to determine whether the Nigerian Financial Intelligence Unit had the powers to bring out such guidelines. And that is where we are.
Counsel to defendant, however, questioned the locus standi of the plaintiff and urged the court not to grant the order.
And on our own part, we have an application challenging the local standard of the plaintiffs to even file this action in the first place. So the court looked at all these applications, and most importantly, the second defendant, that's the Attorney General of the Federation, is not even before the court. So the court felt that the proper thing to do is to adjourn the matter so that all the parties will be served with all the papers we have, the applications we have, and for the matter to be given a holistic consideration.
Neither the second defendant, the Attorney General of the Federation, nor his representative was present in court. Justice A.A. Okeke therefore joined the case to June 21, 2019, to enable all parties appear for a holistic consideration.